Is hard to recall now, buried amid so many years of outrage and scandal in the Trump presidency and post-presidency. But before Donald Trump even entered the White House, practically the very first thing he did after getting elected in 2016, the first thing, almost, was to pay out $25 million to thousands of people who claimed he had defrauded them. This was just 10 days after his election. Thousands of former students at Trump University accused him of running a scam, saying the whole university was a grift, a money-making scheme. And joining all those students was the New York Attorney General's office, because Donald Trump had been running this scam university out of New York. And the Attorney General basically stepped in and said, nuh-uh, not in my state. So Trump had to pay up, and Trump University is no more. A couple years later, the New York Attorney General's office came for Donald Trump's sham charity. The Trump Foundation was ostensibly Trump's charitable organization, but the New York AG alleged that it was basically a Trump slush fund. Trump used it for campaign stunts, like handing out money to veterans charities, even though he wasn't actually giving much money to veterans charities. He used the charity to settle hundreds of thousands of dollars worth of legal problems. He even used it for the charitable cause of buying a $10,000 giant portrait of himself to hang in one of his golf clubs. Do you remember this? The New York Attorney General got that fake charity shut down, accusing it of engaging in, quote, a shocking pattern of illegality. Trump then had to pay $2 million to actual charities. So if you're sensing a theme here, you're not off base. It's all scams, frauds. The university, the charity. In that vein, it could make sense that Trump's entire business might be run on scams as well. And that is what is alleged in today's sprawling 200-plus page lawsuit by, once again, the New York Attorney General. Today, AG Leticia James accused Donald Trump, 3 of his children, and his company of having, quote, engaged in numerous acts of fraud and misrepresentation in representing the value of Trump's assets. Inflated values they then used repeatedly and persistently to get more favorable loans and coverage from banks and insurers. In doing so, James said, they, quote, violated a host of state criminal laws over a period of 10 years, from 2011 to 2021. The lawsuit details more than 200 alleged false asset valuations. But here are just a couple of the big ones. There's Trump's famous penthouse apartment in Trump Tower. Nice place if you're into gilding. And at 10,000 square feet, by New York City standards, it is certainly a big apartment. But for the purposes of valuing his assets, Donald Trump claimed the apartment was 3 times bigger, over 30,000 square feet. And because it was so huge, a few years ago, Trump said it was worth $327 million. Trump's own chief financial officer admitted in testimony to Leticia James' office that that valuation of Trump's apartment amounted to an overstatement of, quote, give or take $200 million. Just for context here, the most expensive apartment on the market in New York City last year was listed for $169 million. Trump said his apartment was worth almost double that 7 years ago. Nice try, Donald Trump. And then there's Trump's Florida Beach Club, Mar-a-Lago. To get tax breaks, Trump signed on to all kinds of restrictions on what could and could not be done with that property, which included a prohibition on turning it into residential real estate. Even under those restrictions, the club was worth a cool $75 million. But when it came time to assess its value as one of his assets, Trump pretended none of those restrictions existed, and the whole place could be developed and sold for residential use. He said Mar-a-Lago was worth not $75 million, but $739 million, literally 10 times its value.
This investigation revealed that Donald Trump engaged in years of illegal conduct to inflate his net worth, to deceive banks and the people of the great state of New York. Claiming you have money that you do not have does not amount to the art of the deal. It's the art of the steal. And there cannot be different rules for different people in this country or in this state. And former presidents are no different.
Leticia James said today that Trump's conduct appeared to violate not just New York law, but federal law as well, specifically laws against bank fraud. And she says there may have been tax violations as well. So she has referred the evidence to SDNY, the U.S. Attorney's Office in Manhattan, as well as to the IRS. But even if no federal charges come out of this, the New York AG has the power to impose severe consequences on Trump and his business. After all, that office already essentially shut down Trump's sham university and his fake charity. James can't criminally indict Trump, and she isn't explicitly seeking to dissolve the Trump organization the way the university and the charity were. But she is seeking to bar Trump and his children from ever running a business in New York again, to bar them from getting loans or acquiring real estate in New York for 5 years, and to recover $250 million in allegedly ill-gotten gains. That is no small sum. Put all of that together, and this lawsuit has the potential to put the Trumps out of business in the state of New York. Joining us once again is Barb McQuaid, former U.S. Attorney for the Eastern District of Michigan. Barb, thanks for staying with me. What do you make of the strength of the AG's case here? It's what do we have? She cites 10 years of Trump statements on his wealth. This is a scathing document that she clocking in at 222 pages. How strong is this given the sort of bar in terms of standard of proof for a civil case?
It looks incredibly strong to me, Alex. This is not the Cliff Notes version of allegations. This is detailed, more than 200 pages, detailing all of those fraudulent claims, some of which you just highlighted. And, prosecutors love cases like this because they're built on documents as opposed to eyewitnesses. Witnesses can fall apart later because their observations can be impeached, their credibility can be undermined on cross-examination. But documents don't forget, and documents don't lie. If you show in one document that an asset was valued at one number, and then in another document the asset is valued at another number, those inconsistencies can really only be explained by, were you lying now or were you lying then? Some people steal money with guns. Some people steal money with lies. These were sophisticated schemes, but at the end of the day, it's really just about stealing money. And I think the documents lay out the case in great detail. You asked about the standard of proof. In a criminal case, of course, the standard is guilt beyond a reasonable doubt, which can be a very high standard and sometimes very difficult to prove, especially when intent is an element. But here, in a civil case, the standard is only preponderance of the evidence, which is just 51%. And so with that standard and this detail and those documents as evidence, I like her odds.
Well, to that end, Trump and I believe Eric Trump had to testify, answer questions about his net worth under oath. That was in August. Both Trump and his son, Eric, took the fifth over 400 times. I think Trump took it 440 times. Eric took it over 500 times. That is meaningful in a civil case, is it not? And with all of the documents, the aforementioned documents we just discussed?
It is. All of us have a Fifth Amendment right to avoid answering questions that might incriminate us in a criminal case. That if they answered questions in the civil case, a criminal prosecutor could obtain those transcripts and then use that as a basis for a prosecution. So we all enjoy that right. And if this were a criminal case, those statements could not even be introduced to a jury. They couldn't even know that the person had invoked their Fifth Amendment right against self-incrimination. That is not true in a civil case. A jury may draw an adverse inference from the fact that someone invoked their Fifth Amendment right. And so the jury would be told when the person was asked whether they have an honest explanation for these allegations, they invoked their Fifth Amendment right against self-incrimination. So that can be a powerful inference in those cases. It doesn't make the whole case, but if you've got other evidence that tends to show evidence of a crime, and then the person stands silent in the face of those accusations, that alone can really be that tipping point to put you over that 51%.
And we now also know that the SDNY, the Southern District of New York, and the IRS, this case has been referred to them. They are not giving up any information on that, but we will be eagerly awaiting developments on that front as well. Barbara McQuaid, former U.S. Attorney, thank you for your time and your expertise, as always.